The CoinMarketCap summarizes everything taught in this video. Additionally, if you would want to be updated on XRP and other cryptocurrency news, like and subscribe to my channel. Now examine this. Federal Judge Analisa Torres, who in July of last year granted Ripple and XRP Hopo a partial success in their struggle against the United States Securities and Exchange Commission, bolstered the cryptocurrency business. The sector made great strides forward with this triumph. Although selling XRP directly to institutional clients violated federal securities law, Judge Torres found that normal users could not obtain XRP from exchanges because Ripple had breached the law. Although the Bitcoin industry and the Securities and Exchange Commission remain divided on this matter, this profile is part of CoinDesk's list of the most consequential 2023. What the precise rules are for digital assets in terms of federal securities regulations. Congress has failed to pass any legislation that would create a safe harbor for token issuers and trading platforms or establish so-called bright lines guidelines. Therefore, the U.S. judicial system is faced with the task of deciding whether the SEC's explanation is correct or whether businesses have a valid point in arguing that the existing laws are inappropriate and out of date. There is more to the asking question than meets the eye. In the U.S., issuers are obligated to adhere to strict disclosure and registration requirements if their assets are deemed securities, the cryptocurrency. Industry claims that these regulations are unworkable due to the disintermediated and decentralized nature of digital asset tokens. Just like their more conventional financial counterparts, trading platforms that list these assets are subject to a rigorous regulatory environment. Further, if an asset is not deemed a security, then these businesses have it much easier when compared to other jurisdictions. The District Court for the Southern District of New York is overseeing a number of crypto actions, including claims made by the Securities and Exchange Commission, making this subject even more prominent. This decision could set a precedent that the industry can exploit again and again because Judge Torres found that Ripple had lawfully sold XRP to individual investors and can keep selling it to them through blind bid hacked sales on exchanges. It was impossible for programmatic purchasers to tell if their XRP payments went to Ripple or another vendor. The vast majority of people who purchased XRP from cryptocurrency exchanges did not put their money into Ripple in any manner, as the judge pointed out in his ruling. The buyer knowingly entered into a contract to purchase XRP straight from Ripple. When it came to the numbers, a programmatic buyer was no different from a secondary market buyer in that it had no idea who or what it was paying. An example of this would be a decision that sent shockwaves through the company and raised concerns about the precedent it set. In particular, Grant Gloveson noted that the decision was highly advantageous for exchanges. The extent to which the ruling would benefit Bitcoin firms and projects is seen through the eyes of an attorney who represents clients active in the cryptocurrency sector. However, it truly is conditional. At this very moment, the decision is being deliberated in just one courtroom. In what seems like an attempt to speed up the appeal process, the Securities and Exchange Commission clearly intends to appeal it once the main matter has been settled. The charges against Chris Larsen and Brad Garlinghouse, two executives of Ripple, have already been dropped by the regulatory agency. Gullifson told reporters that the decision could open a door for projects to get funding if the Court of Appeals upholds it. Furthermore, Judge Torres' ruling may out to be an exception. Judgment was reversed when a different judge from the same court specifically rejected Judge Torres' analysis in the SEC's lawsuit against Terraform Labs. Having said that, keep in mind that the specifics of that finding and the Ripple ruling in particular are undoubtedly case-specific. The time it takes for the Court of Appeals to make a decision is uncertain. Judge Torres has set a schedule for certain additional proceedings that will take place in 2024, so the SEC cannot initiate an appeal until the case is concluded. In Ripple's continuing legal struggle with the Securities and Exchange Commission, CEO Brad Garlinghouse has hinted at a major overhaul. A rumor about a potential accord or major conclusion spread after he hinted that a showdown could be imminent. Legal professionals specializing in Bitcoin swiftly reacted to this tweet. Bill Morgan, an expert in crypto legal issues, has called the excess rubbish. He claims that the legal battle has already been won when a settlement meeting takes place. An epic showdown is not the same as a settlement, he says, taking his time to make that point clear. The reason behind this is that it necessitates finding common ground and achieving consensus on specific matters, while also addressing potential avenues for resolution and challenges to overcome. For the moment, a settlement is not in Morgan's opinion. He brings up the fact that as a general rule, disputes are settled through settlements, which often include the option to appeal. This might be quite worrisome. The settlement's real effects may extend beyond the scope of the current negotiations. After December 2020 and possibly beyond, Ripple's XRP sales may be affected. Not all of the funds that may be traded in the cryptocurrency market have made it to the infrastructure that supports them. The Bitcoin industry is still in its infancy, therefore this is to be expected. One of the problems we are experiencing is making sure our payment customers have a great experience while still offering them a low, highly reliable cross-border payment. It has been necessary for us to build our liquidity trading platforms, integrations, partnerships, and compliance services throughout our journey. We have had to delve into the world of liquidity management to solve this problem. Because these tasks need time to complete properly, it is tragic that many individuals in the industry did not bother to do them. On the other hand, armed with those details, you can approach a remittance firm with the confidence that you can resolve their cross-border payment issue today. A startup that plans to sell high-end goods may be thinking about using non-fungible tokens or stable currencies as payment. So that its customers can interact with both the fiat and digital asset systems. When it comes to managing liquidity, they will have comparable needs. In order to tap into the newly accessible liquidity of cryptocurrencies, having the opportunity to lead and own the payment infrastructure we build has been an honor, and I take full responsibility for its foundational design since it underpins all other components and commercial use cases. Since we are still in the early stages, this acts as our guide. In the course of completing one use case, you may come to realize that some of these other components will be necessary for the next use case. Therefore, please be advised that the information supplied is not meant to be used as trading advice. Any investments made relying on the information presented on this page are not liable for any reason. We highly recommend that you do your own research and talk to an expert before making any investing decisions.